Good morning, Murder Church. Welcome in a little bit late. I apologize. And yeah, if y'all could hit the old like ski, give it a share on X. I appreciate it. Actually, I'll probably need to post on X. I saw Seeking Justice make a post. Thank you, Seeking Justice. I did retweet that. But yeah, everyone, gather round, gather round. We're going into episode 92, Phil Spector. We're ever so close. Let's go.
Let's rock.
Good morning, congregation. What's up? What's up? Make sure my light's on. It is. Yeah, I was not making it at 9. I set my alarm at 8:30. I got up for just a second. I was like, I mean, you can see my eyes are still just like Jesus. I was up way too late. Oh my God, Saturday night, rocking and rolling. Went a little too hard. And yeah, what's up, everybody? Good morning. Is this working? Boom, Carrie, morning, morning. Good to see ya. Good to see ya. Pokemon coming through. Shirley, good to see ya. Pammy in the house. Dave in the house. Started following Dave on X. I saw he's on there. Following each other. Good to see. Salty Sleuth, good morning. Good morning. Salty Sleuth will be appearing on this week's Feral Friday. Her and Lisa, Miss Shorty, are going to be on doing something. Doing something. We'll have to see what it's going to be. It's going to be an interesting one. Motion to Scream coming through here. Good morning, good morning. I'm glad some folks walking through the door. I appreciate it. Brooklyn, good morning. Teresa, good morning. What's up, everybody? What's up, what's up, what's up? Whoa, Kaylin coming in. What's up, Kaylin? Early in the church. She might not have stayed where I was coming in late. Good morning anyways, Miss Dina. Good morning. You beautiful people. Yeah, beautiful people. Yeah, so here's what's going on right now in Phil Spector here. We're getting very close, and if anybody was here Tuesday, they remember the exhibits episode, and it was ridiculous. There's another exhibits one which says they're still preparing for final closing arguments. So I think I'm going to skip that, and if you look here, the next one after, so this one right here is exhibits. You can't see that because of this. Hold on, I can stretch it out. Show my cards here. Boom. And more exhibits right there. So I think I'm going to go to this dude, which I have no real clue why he's here. I mean, I think I thought both had rested because we're getting right into closing arguments, as you can see right here. Have a couple more, have another exhibits after that. After this dude, Victor Pytron Tony. Outside the presence of the jury, outside the presence of the jury, which doesn't say exhibits, so I guess I'm not exactly sure what that'll be. We'll check those out. And then prosecution closing arguments has 4 parts. God only knows how long these are. I'm imagining episodes worth. Another outside the presence of the jury. Defense closing arguments goes for 6 parts. A rebuttal from the prosecution in days of deliberations down below, which I'd imagine those would be quick. So I'm going to look at the chat here. What is the chat saying also? If anybody doesn't mind, I'm going to go to this guy right here. I'm going to skip this exhibits and maybe this exhibits. Because if anyone remembers on Tuesday, it was basically stuff that they were preparing, I guess, for closing arguments that the jury would see. So we're going to be seeing that stuff anyways, and I guess the only difference will be what the judges. But man, they're just fucking going on and on and on about a bunch of bullshit. But if you guys want to watch this exhibits, I'll play her up. Oh man, hate to see that. Salty Sleuth been sick for a few days and haven't had coffee, but I'm brewing a pot. That should get you ready to rock and roll. Hey Kathy, yes, I saw Kathy this morning. Kathy came through and gifted me some loot. Hold on, Kathy. $4.20 this morning through the Cash App. Appreciate that. That is going to continue the wheel also. We got 4 names on the wheel that is happening right now. Of course, we'll give away some cool stuff. I got some cool magnets, some hell yeah, some murder churches. I still got the publicly buzzed coasters, the sticker packs. Boom. And you guys already know, if you're going to get membered up, that would help you get in a book club every Tuesday night after the regular Murder Church show. We go to a members only Buzz Nation book club show. And yeah, we're reading The Stranger Beside Me, and that book we are coming to an end to within probably the next this trial may come to an end about the same time, actually. Some fresh air coming in here either way. So, but yeah, get in there. That's one way that you could get on the wheel. Other ways, of course, and put up, boom, just like Kathy just did there. I think she sent me 420 through the Cash App, Venmo, PayPal, boom, publicly buzzed right there. And then, of course, supers, and I'll read those bad boys publicly and show them. And I don't know what, I need to come down here. I should have done it yesterday. I was down here working on a wrestling video. I still have not fixed my bells. My Stream Deck is still not working. So let me ring them for you. Bing! 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 All right, the only person that answered that seems to that wants. Let me see. CH says the nerd in me is down with exhibits, but I get it's not everyone's cup of tea. So CH is trying to take us through the long way. Leia, welcome in here. Good morning. Good morning. You guys got some bells. You got some bells. All right, I'm skipping it. CH, I'm overriding. Because it's so it's another hour and a half of what the first one was. I'm interested to see what this is. This is also an hour and a half. This will be Murder Church today. This dude, Detective Victor Pietrantoni, takes the stand.
When the court left the bench this morning, we were discussing the letters. I wanted to draw the court's attention to two passages in the transcript of Mr. D'Souza.
Okay.
One appearing on 3298 at lines 8 through 10. Mr. D'Souza indicated with regard to Exhibit X, I don't think I've ever seen that letter before today. With regard to letter Y on page 3301 at lines 22 through 26, I've not seen this letter from Mr. Sortino to the Immigration Service asking him to get permission. He had never seen the letter X or Y before he was shown those letters. My argument would simply be we don't even know if the letters that are presented are the same letters that were actually sent or not. The point that Mr. Brunon wanted to make about the any advantage that Mr. D'Souza may have felt like he had gotten from the prosecution is made through oral testimony. These letters are not relevant to his testimony. He had never seen them before. He doesn't even know if these are the same letters that were sent. There's no foundation for them. Okay. So I would leave that with the court. I know there was a question as to whether or not he had testified to the substance of the letters. He very clearly, as I reviewed his testimony, indicated, I've never seen those letters before.
Well, I don't think it's relevant whether or not he saw the letters. He expressed a subjective awareness of the letters. He knew that the prosecution was trying to assist him with INS. He knew through conversations with his attorney that letters and other actions were being taken. These letters embodied the actions that he believed were being taken. I don't think Mr. Jackson is suggesting that these letters are not the actual letters written by Mr. Sortino. They were produced by the prosecution for prosecution files, so I assume they're authentic in that sense. And again, we're not offering him to prove that he is a material witness or that the prosecution has whatever opinion of him they have. What we're offering him to prove is corroboration of his testimony that efforts were being made to his knowledge, in his behalf, to not only have him remain in the country, to have his work status adjusted and to make arrangements for his family to come up here. All of these things were benefits that he had requested, either directly or indirectly through his attorney. That's why they're relevant. And if we don't put them in, then it's going to suggest to the jury that they didn't really exist when we all know they did, and he was examined upon them.
There's a couple of Supreme Court cases. One, I don't have the cites. PG&E versus Thomas Drayage, Drayage, and Rigging Company. and also People versus
Thanks, Shelley, for
Maki,
putting that in Discord. I
M-I-K-I.
appreciate
And
it.
although these are not directly on point, the Thomas Drage case talks about it had to do with automotive repair bills, but bottom line, the Supreme Court found that it could be used as corroboration where there's other testimony that supports it, and there is. In this case, we do know that certain things were done on his behalf. I mean, the people really can't take a position that Mr. Sorrentino didn't write the
I
letter.
saw that. Kaylin, I was like, hey, I don't know if she made it. I was late this morning. I was an hour late this morning. Kaylin, thank you so much. Good morning.
And I understand that.
I just want to make it clear.
And when what the import of that case was there's testimony, the person is either aware of them or something. In other words, here he's aware things are being done for him. This is corroboration that things in fact were done for him. So on that basis, I'm going to admit those exhibits.
X and Y.
Okay, what's next?
Z.
No objection to Z through
Okay.
E2. Our next objection would be F2.
Okay, F2 is a weapon fired from the Spitz book. Okay, I remember the picture.
It's up here, Your Honor.
I know, that's the one.
Right, there are a couple of photographs like this, F2 and G2. We simply want to lodge an objection that these are not indicative of the actual gun. In this case, they were testified to with regard to GSR in general. I have no problem with that. For these actually to be admitted and go to the jury could be misleading. They may suggest that this old-fashioned cowboy gun is indicative of the exact type of GSR or a smokeless powder or whatever that's indicated in the firing of the Colt Cobra. That's simply not true.
Well, I think there was adequate testimony to support that where that was differentiated, and I think that's in the record, and certainly that can be argued. The objection is overruled.
We have no objection. I'm incorrect.
H2.
H2 and I2. I have to look at those real quick.
Dedication,
Judge, you'll
Dave.
see and we can probably address a lot of these in one felled swoop. With regard to the coroner's data sheets, the 42s that have been testified to by Dr. Pena having been filled out, you'll see that in I2 as opposed to H2. We have a strong objection to the VAT, for instance, is a perfect example of that material coming in before the jurors. This is rife with hearsay. This is not a business record insofar as business records are defined by the evidence code. This is a form and it's blank. If the court can imagine glancing up at that document and the only thing on it, it says worksheet on the top and it says 42 in the upper left-hand corner, and that's it. It's no different than this pad that I use every day. Mine just doesn't have the number 42 on it, and my notes and my thoughts are put down on this during the course of the trial. The 42 is what Dr. Pena chooses to put his notes and thoughts down on. They are hearsay. They are not part of a form that you fill out, or say, for instance, the 20 is very different. The 20 is an anatomical diagram. You'll see a consistency with our objections and non-objections throughout this. We have no objections to diagrams. Diagrams are illustrative evidence as long as there is a foundation laid for them. With regard to these 42s, and there's tons of them, the defense marked everything under the sun, and tons and tons of these 42s. They're hearsay, and there's no exception to the hearsay doctrine. Even if he testified to them and he was shown them, I have no problem with that. But to publish them to the jury and for them to go into the jury is nothing more than taking hearsay statements that are handwritten out and putting them before the jurors. I have the same objection with H2 as well, because I don't believe that any foundation was laid that that's a business record as suggested by the evidence code. So I know that's a long objection, but I want the court to know what each one of these, why I'm objecting to each one of these.
Okay.
This, along with many other like it, were objected to when they came in before the court allowed me to publish them. I had to lay a very strict foundation as to a business record. I think the court made inquiries too as to a number of these documents. The reason that this document is relevant is this is the business record he kept when he went to the scene. It's in the part of the coroner's official file. It indicates it, and I believe Dr. Pena testified that he determined that it was a homicide before he did the autopsy. That's noted in here, and he acknowledged that. This corroborates that he actually put that in writing as part of the official coroner's file. So we think it has all of those relevancy tendencies. It gives the times and so forth, and we think it is a business record, that the foundation was laid as to each and every one of them over strenuous objection at the time. And we think the jury should see sort of the process of the victim as to how Dr. Pena did his job. Certainly, I don't see any prejudice to the people. Typically, it's the defense that doesn't want all this redundant information in, but we think it really helps amplify and explain our case and our theory of our case.
Mr. Jackson, is there some prejudice you want to point out?
The only thing I would, Judge, there's so much of it, I'd have to start looking through each document of it. The hearsay rule doesn't require prejudice. There's an evidentiary standard before stuff is admitted. And one of the things that the defense has consistently confused in their arguments is they say, well, I'll say hearsay. And they'll say, but Judge, this corroborates so-and-so and so-and-so and so-and-so. Corroboration relates to relevance. It is relevant because it corroborates something. It's relevant that I stand out in the hall and,
Shirley, thank you.
say X, Y, Z to Roger, but
For that share on X.
that may not
Share
be
your
admissible
share.
because it's hearsay. They have to, we have to play by the rules, and I don't have to show a prejudice before the hearsay doctrine is invoked. My point is I don't want the evidence code to kind of fly away because the defense consistently says, well, it's corroboration, it's corroboration.
Now, I understand
corroboration.
that. Was the witness questioned about these documents?
I think he was questioned about either all of them or most of them. At some point, I remember Mr. Plord, it was 4 days, so I would imagine he's pretty thorough. There wasn't much that he missed. He walked up and asked Dr. Pena, is this your handwriting? Did you write blank, blank, and blank? Yeah, and all that testimony is there, and they can argue it all they want to. My problem is the evidence code, a strict interpretation of it indicates that this document doesn't come before the jurors. That doesn't hinder the defense's arguments that, for instance, on one of his 42s, Dr. Pena indicated that he said that she died of a gunshot wound to the head and that the mode of death was homicide. They can argue that. That document, however, I don't believe is appropriately published to the jury to go into the deliberation room.
What foundation was laid at the time the documents were discussed with Dr. Pena?
That these are notes that was that addressed to me, Judge?
Anyone?
My understanding, and Mr. Plord can probably expound on this, the foundation was that these are in fact his notes. These are his handwriting. These were during the course of his investigation at various times, either in a meeting, meetings with Dr. Lakshmanan, notes to himself after the autopsy, before he got certain other evidence, after he got certain other evidence, after speaking with so-and-so, he'd just grab a blank 42. They're literally on a sheet like this. I mean, 42s come on a sheet like this, and you just keep tearing them off. And he would write notes to himself. So the foundation is that they're his. I'm not objecting to that.
Are they required to be, I'm asking, at the time he testified, did he indicate there's a requirement if he takes these notes that they be part of the file?
The requirement that he imposed on himself is that there is no requirement that he take the notes, but notes that he takes on the 42, he, as a matter of course, puts them in the file. Absolutely. I mean, he doesn't take them home and stick them in his glove compartment. These go in the file.
And I think he also added on cross-examination by Mr. Plord that they were accurate, they were made at and near the time of the event, and that he kept them in the customary scope and course of his duties and obligations as the coroner. I believe that was in there also.
Judge, on page 22, page 38, 23, we went through basically two hearsay exceptions, the business
give that
record
to
exception
Linda.
in detail with the reference to all the notes, and then also the past recollection recorded as to how he took these particular notes, so I think they qualify for both.
Still
But
trying to
in
wake
particular, the business record exception where he testifies that these are business records, these are part of the official coroner's file, et cetera, each and every one was gone into, because there was objections at the time, so we went through them in detail, and I had to lay a foundation before I could publish any one of them.
Why would they not be then business or official records?
Because the data on at least my understanding about business records is that the data on the records have to come from a source. For instance, when you're a 911 operator and you're taking down an incoming call, they will say, I am trained to take down what is being said, what pertinent information is being said to me. Therefore, the information that goes onto the form has an inherent trustworthiness that can be defined to a source. That source being whatever it is. If it's a DWP, your monthly water bill, for instance, Judge, that could be a business record. Why? Because your water bill is put down the same way, off the meter, off the back of your house, every single month. This is, the 42s that I have a problem with are a free flow of information that Dr. Pena thought out and just kind of interpolated. As his thoughts percolated down, he would just write notes out. And they could have been in a meeting with Dr. Lakshmanan about whether or not to look at the box. And he indicated, I'm not going to look at the box, and Dr. Lakshmanan doesn't want me to look at the box. You know the box I'm talking about.
I understand, but if he basically, and I'm relying on what Mr. Ford just said, if he testified that he took them down, he was accurate when he took them down, it seems to me there's your inherent, how does this differ than any other business record?
Well, if
It's his own thought process. What's more, it's not filtering through another person, which still would be admissible under the business records exception, but he's saying, this is what I was thinking, this is what I was doing.
I guess the difference, I may be making a difference without a distinction. I'm not being very convincing, obviously.
No.
In my mind, it's somewhat, there is a great distinction between, for instance, let's use the example I used a second ago, the 20, which is a diagram.
I understand.
And his notes. The 20 is done the same way every time he cuts open a corpse. Every single time. He looks at the head and he writes down his findings there. The 42, I guess I just look at it like whatever happens to be in his thought process at the time is what he thinks about. And if we're talking about accuracy, by the way, and the defense's position is these are accurate and they have inherent trustworthiness, that document that they just had on there indicated mode of death, homicide. So if the defense is conceding that the accurate mode of death is homicide, I guess I could withdraw my objection. I don't know that they're really going that far. So it seems to me there are things in there that are helpful, obviously, but there may be things in there that are not relevant and hearsay, and that's my position.
I hate to overrule your thought process, but I believe they qualify. The objections are overruled.
That's fine. Then that'll save us a lot of time. There's a lot of these in here, so we can
Okay.
move on from those.
Tell me what your next objection is.
That would be Q2. No, I'm sorry, N2. N2?
Let me look.
Yeah, well, he's doing that. Could Mr. Dixon come to the bench just for one quick second on something?
Okay.
I know there's no jury, but you'll understand what I mean.
All right. All right, we're going to interrupt the exhibits. I understand you have a witness you want to present on your motion for...
Yes, that's correct.
Okay, you may proceed.
They're going to ask me to do this part.
Okay.
Do you solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please be seated. Please state and spell your first and last name for the record.
Victor Pietrantoni, Victor.
Here we go.
P like in Paul, I-E, T like in Tom, R-A-N.
This will be the last
T
ever
like in
witness.
Tom, O-N-I.
Thank you. You may proceed.
If it's agreeable with the court, I'm just going to ask these questions fairly open-endedly so we can get hopefully to the point. Detective, by whom are you employed?
City of Los Angeles,
And
Los
what-
Angeles Police Department.
And what's your assignment?
I work the homicide special section of Robbery Homicide Division.
And was that your employment and assignment in April of this year?
Yes, it was.
At that time, were you asked to participate in an investigation related to this case?
Yes.
And what were you asked to do?
I was asked to act as an intermediary and go and interview a possible witness and report back to a special master.
Okay. And who asked you to do that?
I was directed by my captain, Captain Kyle Jackson.
Did Captain Jackson tell you who had been in contact with him to seek this assistance?
No, he did not.
Okay, did you receive any additional direction other than what you've just said? Well, strike that. Let me start over. What was your specific assignment to do?
Well, a person was identified to us, a Professor Lori Levinson from Loyola Law School, and it was explained that she was going to act as a special master. And an individual's identity was given to us, and we were told that we would eventually report to her what information he had to give.
Okay. And is this information still coming from Captain Jackson?
No, I believe I ended up contacting Professor Levinson.
Okay.
to determine the specifics and to ask her for some direction as to how she wanted it done.
Okay. And what did she tell you?
My initial conversation with her, obviously I introduced myself to her, explained to her that I had not been in this situation before, and asked her for direction. She told me that my partner and I would go and meet with this individual who was identified as Gregory Diamond, and that we would determine if he had any information to give. We'd collect that information, report back to her, and that she would make a determination as to whether she would meet with him.
Was the subject matter of your inquiry described for you?
Pardon me, sir?
The subject that you were going to be inquiring about, did somebody give you a description of that?
All I was told was that an individual by the name of Gregory Diamond claimed to have information relating to this investigation, this trial, and that we were going to go and interview him to see what information he actually had.
So I take it that before the first time you saw Mr. Diamond, the scope of the inquiry hadn't been narrowed to a particular incident or a particular event occurring at a time. It was just find out what information he has about this matter.
That guy early in this trial was
I had no information regarding that.
I've never seen
I don't
anything
know
like it.
if anyone else had received
Can't believe-
information.
Okay. Your partner was Detective Moberly, is that right?
Yes, sir, that's correct.
And did he participate in the same conversation you had
held that dude
with
in contempt.
Professor
If you ever hold
Levinson?
anyone in contempt,
No, I
it should
spoke
have been
to
that
Professor
fucking
Levinson
guy.
directly.
Okay. And did Moberly tell you that he'd received any directions from any other source prior to the first conversation you had with Mr. Diamond?
No, he did not.
Okay. So was it your intent when you saw Mr. Diamond simply to ask him, what did you
He's
know
like, "I'm
about
outta
the
here."
incident, and then report back to Professor Levinson?
Yes.
Okay. Now, up until that point, had you spoken to anybody in the district attorney's office?
No.
Okay. You had a meeting with Mr. Diamond at law school campus, is that right?
No.
Where did you meet with him?
We met at the Newport Beach Public Library.
Okay. And at that time, you made general inquiries of him, of his former employment with the Shapiro law firm, is that right?
I don't know whether he responded as a result of a question we asked, but ultimately that information came out.
And during the course of the interview, did you ask questions about a meeting that had taken place with Mr. Shapiro and other people that you believed were involved with the defense team? I'm talking about Dr. Bodden, other attorneys, that sort of thing.
Objection, Your Honor. I mean, we don't want to hear stuff that we've gone and made great efforts to avoid hearing, so.
I'm going to allow, that question doesn't quite get there, and we're all on guard for just that
Thank you.
eventuality. Okay.
I'm cognizant of that, Your Honor.
Okay.
Did you ask questions about those meetings, or that meeting at any event?
As I remember, we responded to information that that Gregory was giving us. We would ask questions, but ultimately we did not.
Questions between the lawyer and the client, or the lawyers and the other, I'm going to call them, if I say team members, will you know what I'm describing? Dr. Bodden, the other lawyers that were present, the paralegals. If I call that the team, would you understand that?
Yes, I understand that.
Okay. And had anybody instructed you not to ask about communications between the team members?
The only specific instructions that I recall were those coming from Professor Levinson, and that was to go interview Gregory and find out what information he had.
Okay. Just a moment here.
You may.
Your Honor, I don't have any further inquiry on that. Well, I'm sorry, one last question. After you concluded your interview, did you report it to someone else?
Yes,
And to whom?
to Ms. Levinson.
And did you report it to anyone else?
No.
Okay, I don't have anything else, Your Honor.
Thank you.
Just a couple.
Cross-examination.
I just wanted to clear up the time sequence, if I could. So your captain, Kyle Jackson, informed you that you were going to have this assignment, correct?
Yes,
And he was very vague about what the assignment was.
Correct.
But part of the instructions he gave to you to contact Professor Levinson. Is that right? Or that she would contact you?
I don't recall getting any specific direction to contact Professor Levinson. I contacted Professor Levinson for lack of information to find out what she wanted us to do.
And did you do that before you talked with Greg Diamond or had the interview with Greg Diamond at the Newport Public Library?
Greg Diamond, yeah, that's that guy's name.
So there's no question that the sequence here, you get the information or the assignment from your captain. At some point, you talk to Professor Levinson, correct?
I talked to Professor
God, he was
Levinson
annoying.
immediately after getting the information
So
from my captain.
annoying.
And then she gave you certain
Dodgiest
directions, and it was
guy
after that you talked to
ever.
Greg Diamond in Newport Beach.
That's correct.
Thank you. Nothing further.
Thank you. Redirect. All right, you may step down. Thank you for being here.
So he didn't even last that long.
Yes, you can
So
be
what are you going
excused.
to do for
Any
the
other
next
witnesses?
hour in here?
Any witnesses the prosecution wants to present?
No, we're in the dark on this to a great degree. Although I will say this, as I understood this presented to us yesterday, this outrageous conduct, that the allegation was made, and the witness now left the room, that somehow the police detectives went and talked to Greg Diamond without any instructions. Clearly, that's not the case.
Right. Well, do you have any other witnesses you want to present?
No, Your Honor.
Okay, do you want to argue?
Just briefly, the instructions given probably were inadequate, but they weren't the product of anything done by the prosecution. So that's it. I mean, we're not
Okay.
going anywhere with this.
All right, based upon that, the motion, since it's pending, and if you don't want to withdraw it, I'll deny it. There's inadequate facts to support that anything was done improperly. Let me just say, we've probably gone over several times, and actually Ms. Kenny Bodden sort of indicated yesterday, well, you let Mr. Diamond testify, you haven't let us do anything. Well, of course, you've been able to procure any witness that you wanted or do anything you wanted. What I said was, initially, that the motion on its face, because all it had were these unsupported allegations by Mr. Pavlik, they didn't go anywhere. They weren't even done under a declaration. They weren't done under examination. So now, at least as all the evidence that's been presented to me, what you have is, just to reiterate, this individual, who it turns out is working for Mr. Shapiro, contacts the district attorney and says, I have information about the case you want, or you would be interested in. The people recognizing, because of his employment, and I believe he identified himself as to what his job was at the time, very quickly say, we're not going to deal with this, we can't. They do the smartest thing they can, and I'm obviously adding my interpretation. They go and ask me to appoint a special master, which is exactly the right thing to do, because a special master works as a intermediary who is not going to give information to the district attorney if anything is unearthed that would be of a privileged nature. Now, I've been thinking about this, and we all sort of assumed, based upon now unsupported allegations, as to what the detective may have said to Mr. Diamond, but truthfully, at this point, we don't know. We know that there's a danger of privileged information, but certainly the detectives or Professor Levinson do not know what the information is. It may be privileged, it may not be privileged. As it turns out, some of the things in the way of observations turned out not to be privileged. They examine them, they report to Professor Levinson, she reports to me, and we've gone on the record any number of times. Professor Levinson and I agree, stay away from anything that's privileged. Nobody wants to know. Nobody has a right to know. It's for whatever reason that Mr. Diamond came forward. But in the investigation, it turns out that he made certain observations that Professor Levinson inquired of me, and we both agreed, Professor Levinson and I, did not appear to be covered by any privilege. And as we now know, by what the Supreme Court and the Court of Appeal has done, we were correct. They were not privileged. They weren't covered by the privilege, and we have taken that as far as it went with Mr. Diamond's observations of certain things, and then that led to Sarah Kaplan, and then ultimately it was her observations that became admissible and relevant to this case. So as far as any outrageous government conduct, it's non-existent. So the motion is denied.
That's fine. I don't want to argue that any further.
Okay.
But what was troubling about this to us was two aspects of it. One of them was, and I'll represent this to the court, and I don't think, well, people wouldn't have grounds to dispute it, but we can lodge with the court under seal, if you like, a transcript of this initial interview. And it did focus on confidential communication, so that was obviously troubling. The other thing was that the defense was totally excluded from the process, and we're the ones with our client, Mr. Spector, is the one with the entire stake in the action, and we felt it would have been appropriate to, particularly since it was on the eve of the trial, or even at the beginning of the trial, jury selection was going on, to have all of this going on in the background put us at a disadvantage, and it is to some extent still tainting the our defense at this point. But having said that, in terms of proving that the prosecution or anybody else associated with them set an inappropriate course of action off, we haven't established that, and we've submitted it on what we did establish.
Okay, I appreciate that. My final comment will be the reason the defense wasn't included. This is basically what the prosecution is doing. They're investigating a case. Now, in the initial, they don't have to inform you until they have their facts before them as to we have a witness, we don't have a witness, we have inculpatory evidence, we have exculpatory evidence we have to turn over to you. The bottom line is until Mr. Diamond was investigated, you didn't have a right to know. It's someone who came to them as a witness, and the only reason the court was involved was appointing the special master and making sure the special master was had some direction as to where she was going because of the nature of the privileged information. And as soon as the information became known and all the facts were known and it was reduced to a report, you were informed. And it was, the timing was as the people got it, as the court got it from the special master, and that's why it happened the way it did. All right. With that in mind, that motion is denied. I don't think there are any other outstanding motions in this case. I think we have dealt with everything, every motion that was filed. If not, I'll consider it abandoned by either side, because otherwise we need to get by it. Okay. Now, back to the
Hear a
evidence.
cell phone?
Into the section as well.
I thought I heard a cell phone.
Okay.
If I did, they're lucky. Judge Diehard did not.
Police report under the evidence code.
Yippee-ki-yay, motherfucker. That'd have been it.
I'll wait till counselor just... And two.
And two,
Which is the list of the crime scene law.
it's
Yes.
crime scene law.
Right.
In and out.
It's the in and out log, and I think it's relevant because it shows the number of people that were in and out of the crime scene. A lot of testimony about all of
this is
that
crazy.
and what effect it may or may not have. And so I think this is the actual log that's kept as a record.
I will make one available for you, Brooklyn.
And I think it's, I'm sorry.
I thought it was established as a business record, and certainly the relevance is to show the number of people that came onto the scene, which is an issue.
Whether or not the scene was contaminated in the foyer.
Right, that's the argument that's going to be made from that.
Well, there's two things about that. Number one, once again, I didn't argue that it's not relevant.
Okay.
The issue is relevant as to who came and who went. This is part of a police report. Police reports are not allowed. This is kept in the regular course of keeping a police report. Not a hospital record, not another business record, a police report. Police reports aren't admissible. They never have been. I mean, otherwise...
Portions of, no, that's too broad a statement. Portions of police reports can be admissible. If it's done with an eye towards litigation, it's not. I don't believe that's a correct. If you want to show me a case that says no portion of a police report is ever admissible, I think that's incorrect. We can I'll put a little mark around that.
Asterisk.
I think I can resolve that pretty quickly because I don't think that's the law. But if you find a case or something, that's fine.
The second thing is, I would argue that this is, as I just heard counsel argue, that they're going to use this to establish how the crime scene was contaminated. They're talking about the foyer, and this is not an entry log into the foyer. This is an entry log into the crime scene, which is down at the bottom of Alhambra. I'm sorry, down at the bottom of Grandview. So it should not be used in a misleading fashion if, in fact, the defense wants to use this to establish how many people came on the property. That's one thing. To argue that this is indicative of how many people were in the foyer under 352, that would be, I think this is misleading.
Don't forget who has the last argument.
That's a good point, Judge.
Okay?
All right. We'll look for, I'll look for that. I think there's something in the evidence code concerning police reports, but we'll
Okay.
get to that in a minute. My next objection, Judge, if you want to jump to Q2. Actually, Q2, yes.
Okay.
Thank you. That is same objection I had previously with regard to the Spitz book diagrams.
Okay.
This is not the actual gun. It's misleading. It's not. We have no idea how the Colt Cobra reacted in this particular issue. I'll submit.
Same ruling, it's admissible.
Okay. If we jump to V as in Victor, the second.
Okay. Document Bates 2590.
And I've already submitted my arguments for this. This is out of a sex assault kit. I believe it contains hearsay information, the same as the coroner's report. I'll submit.
Same rulings, it's admissible. I think
With
you
regard to
F3.
C3, actually,
You say you agree.
correct. They are withdrawing that. We have
Okay.
no objection to it.
C3 is being withdrawn?
Yes, it is, Your Honor.
Okay, C3 is not being offered in evidence would be more appropriate, all right?
But you know what, Judge? Hang on just a second.
Sure.
I changed my mind.
Okay,
I took this out in anticipation of the rest of the 42s not being in. I didn't feel like it was fair for me to want this and not the rest of it. So since the court has ruled that the others, a foundation had been laid for the others, I think this is admissible as well.
Okay.
Sorry about that.
no problem.
No, they wanted it, I guess that's fine.
Okay.
Okay,
The next one we come to is F3.
Excuse me, I'm sorry. That's in.
that's in.
Okay.
F3. I'll overrule myself. That's going to come in.
F3, okay. F3 is in.
G3, Judge.
It
is
says agree.
Same thing.
Okay, same ruling in. I3, there's an
I'm
objection.
sorry, my mistake. G3, if I can speak for the defense, I believe G3.
Oh, they're not offering it.
Correct. I don't think they were offering that. but-
We are not offering that.
All right, G3 is not offered.
Can I take a quick glance at this?
Sure.
I'm sorry.
Absolutely.
Given some of these,
So I'd pop it in here real quick. 11 months. And so sorry I'm late. I'm watching golf. I bet Dan's watching the same golf you're watching, I would imagine.
autopsy things, we made our objections based on previous objections, so if I can have...
Just for the record, the reason we didn't offer this is that basically the typed up version.
That's right.
This is just a handwritten that was typed up, it's just duplicative.
That's right, it is. It's exactly
Okay.
duplicative, so I don't necessarily need this.
So G3 is not offered, all right? H3, medical history.
We're offering.
Yes, we are.
Yes, there's an objection.
It needs to be redacted as to certain portions, but
Who's medical history of,
this is a form that she filled out in, it looks like mid-01, when she saw Dr. Batra, B-A-T-R-A, Batra maybe, and it talks, it basically gives her history regarding headaches, about bleeding, et cetera. This is a form that's filled out by Miss Clarkson, kind of a doctor's, fill out these forms before you see the doctor thing. Going through it very fast, but it gives sort of her rendition of her medications. There are certain things that she talks about coughing up blood. She talks about having medical problems, including bleeding, etc. And you're going through it so fast I can't.
Sorry, can I go back?
Okay, let's start with the second page. Medications, headache medications, and then the next page, just a list of medications. There, nothing. You can't see if there's anything objectionable. Then we've deleted a certain portion of it. And then we get into prior doctors, other than serious headache problems, etc. And then basically this shows a long history of it. Started at least in 01, and then it goes on through 02, and then. There was one other problem that was with this, I can't remember what it was. It ties in the Long's pharmacy records, and it talks about, go to the next page. The multiple checks, frequent headaches, 4 checks, and then other maladies, and then also there's one that talks, I think the next page talks about the bleeding disorder.
One of the things I think we should be sensitive to, given the fact that this is on television, this is televised.
Right.
A lot of this stuff is not, there are some extraordinarily sensitive things in some of these medical records. I haven't objected while Mr. Plord makes his offer of proof. The long and short of it is, these are Botcher's records. Botcher didn't testify. There's no foundation to these medical records. There are foundations to other medical records, to which we had stipulated there's no foundation to these, plain and simple. There are also extraordinarily sensitive things on these records, like what's on the board right now, and I'd appreciate being taken down immediately, that are obviously extraordinarily prejudicial. Under 352, this court would never allow this kind of stuff in, and it's rife through here. So on one hand, I can appreciate the offer of proof that we're all trying to make convenient for the court. On the other hand, with regard to the medical records, I would appreciate it if counsel would work with me to be a little bit sensitive about these things. For instance, displaying that on the...
Okay, I think, is this this thing we've talked about before?
No. Different stuff.
I thought,
No, we did. There were certain areas that we weren't going to get into. We'll redact the records according to the court's rulings. That's not a
The
problem.
bottom line is, why isn't it a statement of her then existing physical state if it's relevant to what happened? In other words, it's in her own writing. I think everyone's familiar with her writing. It's a statement of her then, what she perceives to be her then existing physical state. And then the question becomes, is it relevant to the issues in this case? And certainly some of them are. So part of it would be admissible without any other. You don't need the doctor to testify if the handwriting, everyone's satisfied it's her handwriting. She's basically saying, this is the way I feel, this is what I suffer from.
And we subpoenaed the doctor's records, and we get an affidavit of the custodian that's part of his medical file. So I think it's part of that medical record of Lana Clarkson. And there is no question as to the authenticity of that. We just need to clean it up, is our position.
Well, then we're in the position of, I mean, this may be the, and I understand if it is, if the court has taken a position that if she wrote something concerning her...
This is the same as saying, did you talk to Lana Clarkson? I'm using an example, yes. Did she tell you how she felt? Yes. What did she say? A, B, C, D, E. The only question then becomes, are those items relevant to this case? Merely stating your physical condition does not become relevant if it doesn't have something to do with this case, but several of these things do, and what Mr. Plord is indicating, they do need to be redacted. There are items in there that are not relevant to this case, but once redacted, it seems to me they would be admissible. If you can't agree as to how to redact them, then you need to come to me to get a ruling.
If that's the court's ruling...
That's my ruling, but
that's fine.
If the parties can't agree, then you let me know.
And Mr. Plord, on the Botcher records, you're aware of the sensitive issues that we want redacted.
I will propose a redacted version to you.
Next, Your Honor, and I'm curious about this. I would ask if Mr. Rosen or whoever is the proponent of these is seeking the admission of I to the third.
Well, I think that's been made before. I mean, I sort of ruled it was inadmissible.
Right.
We're calling it Lana's life story. That's
Right.
the document.
I'm curious why that was not withdrawn.
Well, they may be protecting their record.
Consistency, we believe that, and we're going to ask the court to reconsider its ruling, given all the testimony. We believe that there's certain portions of the record of that story that should come in, given all the evidence that came in our case.
My single ruling, one, we don't know whether there are certain
get Phil
events
on
that
this
clearly
episode.
relate to items that have been
Gonna bring the
testified
glue
to,
out
but we
myself.
don't know whether this is part fiction, part truth, embellished, not embellished. It appears that the last item she wrote about was back in the 80s, many years prior to her death. I think I cut it off at 88 or 89, and I did that based upon the last entry, and she was talking about a movie she had made, and we were able to date the movie. For all those reasons, there's all sorts of problems with this. It's different than the emails. It doesn't qualify. We don't know what the basis of this was, so therefore, the court is finding it's inadmissible. Okay? I mean, we've had a lot of discussions, and that's basically my ruling. Okay, so that's, I-3 will not be admitted.
J3, Your Honor, is a coroner's inventory dealing with medications.
It's a part of the coroner's file?
That's correct. It's from the Department of Coroner. I don't remember, quite frankly, if Barbara Nelson laid the foundation for this or not. I know that Barbara Nelson testified. If she did, I'll withdraw it. I just don't remember it.
It's in. K3, redact, K3 is in, but it needs to be redacted.
Correct, with only the relevant admissible medicines.
Okay?
Yeah, Mike, how do they propose to redact there? We'll work it
The
out.
two of you will sit together and see if you can agree, and if you can't, you come to me and I'll make a decision.
L3. L3, we're seeking not to offer.
Okay, L3 will not be offered. Do you want to check that, Mr.
May I
Chairman?
take just a quick
Sure.
second glance at this? It's hard for me to see it. Can't read that. I need to see the actual document.
Our book is different than the one
Can you make
here.
this larger?
This is the note.
All right, we're offering it, Your Honor. I'm sorry.
This is
The exhibit in my
L3?
book is not the correct exhibit.
Okay, so you're offering L3?
Yes.
What is L3?
L3 is a note that Dr. Pena testified to that he took of a conversation he had with Donna Clarkson within a few days of the death of Lana Clarkson, where he talked about her being depressed over the holidays. He said that was maybe the year before, and that she was a waitress at the House of Blues. No psychiatric history. That's that little scribble. And referred to, and said that Dr. Batra was the doctor, and I think I just redacted the phone number, and that's Dr. Pena's signature. He talked about that at length as being the only history he ever got regarding her psychological state of mind, etc.
Okay.
My objection would be multiple levels of hearsay, notwithstanding that this is on a 42, and I understand what the court's ruling has been concerning that. Now we're talking about an out-of-court statement written down, not under penalty of perjury, from Donna Clarkson, not under penalty of perjury, referring to a Gopal Batra, which is a third level of hearsay, not under penalty of perjury.
I'm going to sustain the objection as this one. This is not reliable because it is based on hearsay. It is total hearsay. There's no basis. I mean, the statements themselves would not be admissible, so I'm going to keep this document out. Whatever testimony he testified to concerning that, obviously that's in. Testimony is testimony.
I think you pretty much read the whole thing, too.
Well, then you're free to go ahead and basically, if the transcript supports it, you're free to argue. Frankly, this evidence, I mean, it's not my job to say, and because I thought about that a lot this morning before we started, is that there are so many levels that so much of this evidence has come into. A lot of this really becomes technical arguments. The truth is the evidence is in front of the jury, but I'm going to keep this document out.
I'm sure you will.
Okay? You're free to argue whatever Dr. Pena testified as to it. If he did, if it came in over objection or without objection, then it's admissible. Just the document itself. Okay?
That's fine. I think that takes us to M3.
Yes.
It's a 42.
My same objection to this 42.
Same rule, and that's N3 we're talking about?
M3, M as in Mary.
Okay. So that's admissible.
Then N3 is, I have it as another letter dated March 21st of 05 from Doug Sortino.
This is the letter, Judge, to remind you that
This
was
is,
sent.
are we on now 03?
We are on N as in Nancy 3.
I have coroner's notes on mine. N3 says Bates 3978, 3979 coroner's notes. That's on your,
Correct. It indicates coroner's notes. It's actually the correct Bates page numbers, but it's a letter to the coroner's office.
from Mr. Sorrentino.
Correct. Sortino shot a letter off to Dr. Lakshmanan with an inventory of the box that he was sending him. That's what this letter is. Once again, it's hearsay. Nobody has testified to the accuracy of this, what was in this box, what was in the containment, that Dr. King never looked at, that Dr. Lakshmanan never looked at, just put in his office and locked up. It has never been seen since. This has absolutely no relevance to anything because nobody's ever seen what's in the box. So the letter has no relevance.
That's what's relevant.
That's what the point is that the DA takes over their investigation, gives them a box full of investigative materials that they just don't even look at. And we think that goes to the weight and credibility of the expert opinions from the coroner.
Except for the fact that you gotta cross some evidentiary bridges. You gotta have Dr. Doug Sortino testify to what he sent Dr. Lakshmanan, and they didn't. They could have called him. They didn't want Doug
No,
Sortino.
that's what they're arguing, in essence, what they're trying to articulate. This is being offered for non-hearsay grounds. It's the mere fact that it was sent. That they want to argue that the DA took over the coroner's investigation and tainted it, if you will. That's what they've tried to establish through witnesses. It's not the truth of the letter, it's the fact that the letter was sent that provides some, from their standpoint, some argument that, see, the DAs are telling you what to do. They're giving you stuff to examine.
Okay.
It becomes non-hearsay.
I understand that, but there has to be a foundation for the letter, Judge. They had to have called, I mean, the defense they just mark anything that they want to mark. They didn't call Lakshmanan, they didn't call Doug Sortino. Had they done that, I wouldn't be objecting.
Okay.
But they didn't do it.
Was there any witness that testified to preparing the letter and sending it?
Yeah. No.
The objection is sustained.
03, Your Honor, is the same thing. It's a different letter sent at a different time, but the exact same objections apply. Doug Sortino didn't establish the preparation of this particular letter either, and Dr. Lakshmanan didn't indicate the receipt of this letter.
Yeah, but
Yes, Mr.
Judge, it really doesn't matter who sent it. If somebody snuck in and got to Doug Sortino's computer and composed this letter and somehow got his signature on it, would be interesting. I don't think anybody thinks that's what happened. It is, as the court said before, it's the influence of the prosecution upon the coroner's office that's relevant. In the other instance, the fact that a bunch of stuff was sent over there but not looked at, that's the relevant fact. If there was nothing in the box, there was a belief created that there were relevant items in there that they didn't look at. That's what the relevant point is, not what actually was in the box. And this is the same situation that they're talking about, a psychological autopsy. It doesn't matter what the source of the information is. We're not offering it for the truth per se. We're offering it for the influence on the investigation.
And I understand that gets you by the hearsay objection. It doesn't get you by the foundation objection. Had Judge Sortino been called, did you send this letter? And you know, if you said yes, and then there were objections after that or whatever, you get past the hearsay grounds. I don't have a problem with the hearsay objection.
It's part of the coroner's file. I think we did have a foundation that it was sent. Well, it was received by the coroner, put in the Clark's file. In other words, it's part of their record there. Now, did we have Judge Sortino testify? No, we didn't. But I think circumstantially that gets us, to the point where, okay, circumstantially it appears that the letter was sent, put in Lana Clarkson's file. People treated it as a publication or as a letter from, the prosecutor on the case, which I think the court can take judicial notice of, on official stationery, and it ends up in the coroner's file in the correspondence section regarding this particular case, and it deals with case numbers and coroner's case numbers and so forth. And Dr. Green said, yeah, that was in the file. So we'll leave it at that. I think that's probably enough to get by our foundational requirement.
The foundation is not that it was written by the district attorney, but that it was considered to have been written by the district attorney by the people that received it. Foundation normally goes to the authenticity and accuracy of the contents, and that's a hearsay concept. That's not why we're offering this. We're offering it to show that the coroner's office believed that this was sent by the district attorney's office, and that's the foundational fact we did establish.
I'll wake up some point
And
today.
circumstantially, all the people that are named in the letter are witnesses that the jury's heard of. At least a lot of them are.
Well, to some degree, the letter is self-authenticating.
Right.
We know who the players are. I don't think the district attorney is making a contention that this was not sent by the district attorney's office. I'm satisfied for the purpose that it's being offered and the purpose it's being used. It's admissible. The objection is overruled.
Thank you.
Is that true for the prior one as well?
Yes, and that means I change my ruling as to M3.
Thank you.
I know you're not happy, Mr. Jackson, but that's the way I analyze it.
I understand, Judge. I'm not trying to.
No, it's fine.
I'm
used
just
to it.
thinking of legal arguments. I mean, it seems to me that the defense's argument.
Well, you think about it tonight and come in, and if everybody can revisit some of these. If you think you find a case, I mean, obviously I do this on the fly.
Sure,
based on
I
my
understand.
knowledge and experience, and if you come up with something specifically that says I can't, I'm happy to look at it.
And
from either side.
Don't take my deep sigh as frustration with you. We've been together a long time. I'm not taking issue with you, Judge. I'm trying to think of these novel defense arguments that hey, look, Wink, wink, nod, nod. We all know where this stuff comes from.
No, but that's actually a very good argument. I mean, it worked
Obviously,
for-
it convinced you. I'm not taking issue with that. The point is, I guess I am sort of a stickler with the evidence code. That's fine.
Oh, I agree. I agree that I am not, if I don't believe it qualifies under the evidence code, I don't make up my own exceptions. But there are lots of, exceptions, and you have to sort of think, why is it being offered? What's the use? Who testified to it? What are the facts about this? And bottom line, again, I don't think there's an exhibit, maybe with the exception of Lana's life story, because that had a lot of, if you will, inflammatory matters in it that is going to change one thing in this case. Now, I can't read the jury's mind, and none of us can, and I could easily be mistaken. I don't think there's very much crucial. When I say crucial, it's important to your arguments and to support. The jury is well aware of all the facts in this case. They're just waiting to have it sort of put into context through argument, but there's nothing of a shocking nature here.
I'll leave the court with a single thought.
Okay.
I would ask the court to inquire of the defense if their recollection is that Dr. Pena said he ever even saw these letters. My recollection is, even when asked and shown the letters, because he was shown both of them.
Right.
Did you ever even see these letters? Did you know they were written? His answer was no.
Why don't you take a look?
One of them, he said that, I know, even though it said CC Louis Pena, but there was testimony that was part of the coroner's file. I do remember that. And he did talk about the box being sent over to Dr. Lakshman, but he was told, I don't want you to look at it, and he testified.
Again, the important is that the box was sent over. It's for their argument. In any event, if you come up with something specific, let me know tomorrow. Perhaps it may be that one or the other of the letters would not be admissible. We're on to P3.
Your Honor, P3 is it's a printout of
Lana's treatments.
certain.
I know what it is. It's a SAG insurance record authorizing psychological treatment. It was subpoenaed, and the custodian returned an affidavit showing that it was part of their business records. And basically, the next page is the area of inquiry. This is in 1994, so it's a bit remote, but it shows that she was being treated for a particular condition. Dr. Pena reviewed this, testified about it. It was an anxiety disorder. He explained what that was. But the treatment goals is why we wanted to have it admitted. Basically, the goal was to, quote, get over not having a father, comma, not crying all the time, end quote. And we believe, based upon the testimony of the witnesses, Mr. Sims, other witnesses, that Lana was crying all the time. This shows sort of a history of this now, and it's not just an isolated incident, because this goes back to 94, where she's getting some type of psychological treatment for not crying all the time. And now we have, a number of years later, 8, 9 years later, where she's still having the same problem. Now, did she have it all the time? No. The evidence is the evidence.
Sounds like it's a great argument for the people, with all due respect, that she has crying jags and she doesn't. I mean, if you want it in and you want it out, up to you. You folks make your decisions. I'll rule on it.
I understand the court ruling, but my position is this is remote. It's 1994, unless the defense is going to argue.
The question is, did Dr. Pena testify to this document specifically, that he used it in any way, fashion, not that it's part? What did he testify to about the document?
Yeah, he said he considered it, he didn't give it much weight, et cetera, et cetera. He didn't put much stock in it at all.
If Dr. Pena considered it, then it's admissible.
I agree. I think Dr. Pena considered it when Mr. Clord showed it to him.
Wait, don't talk over each other.
Sorry, it was sent to him it was one of the few things that was sent to him by the district attorney's office, along with a couple of reports and so forth. It's not something I showed to him first time. He said he had received this, and he actually talked about it, et cetera, and he basically said it didn't change his view of things, because he got it within the months before trial.
Okay.
I'll withdraw. We'll keep it in.
Fine.
We'll keep it in.
Okay. Objection it's received.
One cool bit of news that I got in Phil Spector world is, I think it's next Sunday. Yeah, next Sunday I've got another Jack episode, Never a True Word. Got an interview, a Phil Spector interview that he's going to break down. That'll be a cool After Murder Church thing next week.
Withdraw the objection.
R3.
R3, which is a Bates email, Bates stamp, it's email.
Right.
I keep looking at who's this guy Bates that testified now?
This is the bookmark of the depression on her computer at a certain date and time. And this is a kind of a printout from the computer expert that was testified to, where basically Lana Clarkson, and we know the date, 6902, is the date for the RSVP for the advertisement for the SAG depression alcohol screening and so forth. And it was referred to on a bookmark. I'm not sure what that really means computer-wise, but there was a lot of testimony about this, how it got on her computer, what this, whether it was an email or whatever. Frankly, after the testimony, we think it has some relevance, but not as much as we first thought.
Mr. Plord and I have talked about this many times, and he gets this wrong every time. This is not a bookmark that Lana Clarkson put on her computer. When you go back to your computer,
I remember the testimony now.
The Fortier, the computer guy, did a search, and he happened to call the search Clarkson-depression references. This is totally misleading, and he was asked on cross-examination and direct and reiterated this.
She would get things because
Mass emails.
Mass email. The objection is sustained.
Thank you.
All right, I remember this now.
The next one, Mr. Rosen, what is it, T3?
Let me just check here. T3 is the next one.
It was our, you know what, I think I may have I don't think I had anything on T3.
This is an email to Peter.
Right, I think this may be a mistake on my part. Let me glance at this.
Okay. No, you're not. She gets rest in between this. She's doing fine. Even if she does keep changing her appearance. Are you on the run? Are you a fugitive of some kind?
What was that movie that David Jansen starred?
Rosen makes a reference and everyone just shuts up. That's Rosen's life.
That's a mistake, Judge. I shouldn't have.
Okay, the objection is withdrawn. T3 is received.
I love it.
There's W3 needs to be redacted.
That's right. There
That's some
are
breakfast. There we
reasons
go.
that we've talked about at the bench. There are certain medications.
Once again, redact them, and if there's a problem, come see me.
Line 3, Your Honor, is Ms. Clarkson's date
Yeah,
book.
we don't
and
know where
it's-
Phil is
it looks like
currently,
it's
but we're
almost
going to
the
go ahead and
entirety of the
proceed
date
because we
book.
feel like we may find him.
The
but
problem I have is relevancy.
He is
Only
currently
the
missing.
page or the pages that Mr. Plord deems applicable and has had a foundation laid for. For instance, the Bainbridge, that
Right.
entry would be fine, but this entire thing I think is overbroad.
Well, the defense needs to get down to the pages they want on Y3, and then we'll see. But the whole day planner or day runner obviously is not admissible. It has inadmissible because it has inadmissible items in it.
Okay.
So
We'll indicate redact on.
Redact on Y3, okay. Same as the W3.
Okay?
Z3 is, these are hospital records. They look like nurse entries.
Right.
It is nice to say we are preparing for the closing arguments, though.
Okay.
I must say. But god dang, looks like those are long as fuck.
Testified to by.
Need them?
Just look.
Well, this lady
These
did
are
change her appearance
medical records.
quite a bit. I look like a completely different
They were
person around my
testified by
crib.
the Cedars-Sinai custodian, etc. They're basically records of her hospital course of treatment, prescriptions that were given, nothing regarding the infamous fall and breaking of the wrists. Quite a bit about it.
Yeah, let's come.
Shows that she's being given medications.
Phone that's ringing?
Pardon?
Is there? Oh, okay.
Oh, someone's phone. Here we go.
Anyway, go ahead. I'm sorry.
Yeah, and these are authenticated by a business, hospital record custodian. So
And the relevance is for these? What's the relevant portions?
the times that she's in the hospital, the fact that she's been given Paxil shows on one. see if there's anything else. And there was testimony by Dr. Pena as to that too, also.
As to this particular document?
Yes, it was. I think we showed him this document, and he acknowledged that she received. I'm pretty sure that he.
Not pretty sure.
I think he was cross-examined. I'll get the page here.
Okay.
And our objection would be that Mr. Plord said that there was a custodian who testified to the foundation of that.
No, we have an affidavit from the custodian.
I'm sorry?
An affidavit.
In other words, we did a subpoena, and it was returned with it's part of a packet of records from.
With a certification.
Right, and then I think Mr. Rosen, later on, we got the custodian to testify to certain other records from that pack too, but they're all the same records.
Well, that may be. They may have gotten an affidavit for a subpoena ducis tecum. That's not admissible in, that affidavit doesn't make it admissible in court for foundational purposes.
I think the affidavit is to circumvent if it qualifies under the statute that deals with that, so you don't have the custodian come in and testify, because the affidavit takes care of that foundational requirement.
Similar to the phone lines.
Well, are you looking for your reference to Dr. Pena having testified to this? And what year is this from?
This is the Cedar Sinai Hospital records for Christmas 2001. It's when she was admitted to the hospital for a broken wrist.
Okay.
That hospital stay. Page 4185. Where it starts and then it goes on. We've talked about that subject for a couple of pages. Actually, that's just that's part of the long records. I'll have to get that.
Okay, at this time, this Z3 is provisionally, the objection is sustained. If you can show me where it was tied into testimony, then I will reconsider. But it's on you. Right now, the objection is sustained. If you bring something in, I'll look at it.
Your Honor, with regard to B4, this is relatively simple. All I'm concerned about, I object to the last sentence in the email. It's salacious. It's not relevant to anything. This is a letter to Hugo Quackenbush. I would simply ask that the defense redact the last sentence. And if they don't want to, then explain why that's relevant.
Are we talking about B4 or C4?
B4.
I'm sorry, no.
I'm sorry.
Talking about
A4.
The objection is to B4 on your sheet,
to B4, which is a 42.
but C4 indicates that it's a letter to Hugo.
That's what I'm saying. I'm confused because he's talking about the letter and the one that says objection on the sheet of B4.
Mr. Rosen, let us find out if it's got the right.
I'm with you, Judge.
Okay.
I see. It's actually, I believe it's actually A4.
A4?
There is
That's listed as Lana's loan agreement.
Correct, but there's a letter associated with it or attached with it. The letter that came with it, and the last sentence of the actual narrative of the letter, Mr. Rosen, is what I'm concerned about. Otherwise, I don't care.
Last sentence.
Mr. Rosen actually read this from beginning to end, I think.
I'm sure he did.
But there was something at the end, I can't remember what that was.
I'm looking at the last sentence, and it says, you also agree that this...
Don't read it out loud.
Again, don't read it. Okay. Well, why don't you give that to
Well,
us?
someone's going to need to show it to me.
Okay.
Yeah, the court needs to see it.
All right, bring it up. Yes. Oh, that's absolutely, what's the relevance to this case? Mr. Plord's trying to come up with one.
I'm thinking, I'm trying to read it, it's so small. Who Hugo was this older gentleman that Ms. Clarkson had a relationship with. She borrowed a lot of money from him.
Yes.
No doubt. And basically, I think that the way she got that money is really exemplifying that last paragraph. I'll be honest, that's exactly what was going on. And she's the one that, and Hugo is also the person through another letter that she's sending the false letters to.
I understand that.
basically, at the end, I think Hugo's not happy with her, and that, I think, contributes to issues related to her state of mind. That's the best argument I can make.
Not bad for thinking on your feet, however, the last paragraph will be redacted.
Thank you, Judge.
Okay, that's A. Now what about,
That's a B4, right?
no, that's A4.
A4, B4 will withdraw our objection based, actually, I want to interpose the objection, but I understand what the court's ruling is.
Okay,
It's 42.
so that's, B4 will be received.
And we can jump all the way down to K5, so
Okay?
we're actually making some progress.
K5, it says keep, I guess the defense
means-
is not offering it, the prosecution wants, it's a photo of the front side of a gun.
Yeah, we're seeking to withdraw.
And it's this photo, the foundation of which has been laid by Lynn Harold.
Okay, that's the serrated ramp of the gun.
Correct.
We actually,
We have a different photo, Your Honor.
Okay?
Let me,
No, we're good. You have a different photo. This is it.
no, which one is right? This one?
This is right next.
this is right.
We want this in.
We want this in.
Okay, so that's in. Okay, K5 is in. L5, there's an agreement that it will not be offered. Document from Renteria's notes.
That's correct. There's
Okay,
absolutely.
L5 is not being offered in evidence.
Okay.
R5, a photo of a barrel gun is not being offered in evidence, but now the prosecution wants it in.
Hold on a second.
Certainly.
I'm sorry, some of the exhibits that were given to me don't match up.
This is how you begin to find out, Mr. Rosen. This is,
Well, it's only been 5 months, Your Honor.
okay.
We're on K, R5.
Mr. Blume
What?
is preparing to make the final argument.
In here,
This is these are
Tip.
just subtle little notes.
Morning,
to
morning. Damn.
You're not off.
I like to
But
hear.
the people want it.
Correct.
Yeah, I don't think we brought this up. I'm
Electric
not
shock
sure.
from the
At least that
buzz,
was my recollection. That's why
baby.
we withdrew it.
That's a shot taken looking down the rifling of the barrel, Judge, with a little bit of unburnt or burnt smokeless powder in the barrel.
Who testified to it?
I believe Lynn Harold did.
See, that's why we withdrew it. We marked it, and we never got into it with it. I actually marked this with a different witness, with Mr. Renteria, and I didn't use it, and that's why we withdrew it. And I don't believe that Lynn Harold used this photograph anyway.
What I need to do is, at this point, it is withdrawn. However, if the people can show me where they can link it to testimony, then I will change my ruling
That's
to
right,
admit
Shirley.
it.
Sure.
That's fine, too.
Okay?
Your Honor, I think not admitted is at the moment rather than withdrawn.
Right, I'm sorry. They're not, right. When I say withdrawn, what I'm really meaning is not being offered in evidence. I'm sort of using them interchangeably. And so right now, it's not being offered, but if the people can show the link, then I will admit it into evidence. The next is X5.
And we're not offering that.
People.
And we would seek to have that admitted. The statue in this area of the foyer is,
Again, the only question I had, did somebody testify to it?
I don't know that somebody testified to this exhibit, but there was testimony about, I believe, the statue being tipped over.
Right, there's a lot of testimony regarding the statute, so we don't really object to it.
All right, X5 will be admitted.
That takes us to the next one.
Wi-Fi photo of chair from back right.
This one I know we didn't have testimony on, so that's why we're not offering it.
Okay?
Your Honor, this is a,
And I think the people had one that's almost identical to it that they're putting in their case, and so that's why we feel it's just duplicative, but if they want it in, that's fine too.
quite frankly, there's so many pictures testified to. I can't remember if someone testified to this picture, but it's very obviously Lana Clarkson as she lay in state after she was shot, before her body was moved, before the chair was moved, and it shows blood dripping down the right side of the chair.
Prosecution, I think, introduced an exhibit identical with the ruler and with the blood, would appear to be on the seat of the chair below the elbow, the right elbow.
Well, if somebody, I realize it may show something, if nobody testified to it, however, I'm sure there are other pictures. Until you can link it up to me, then it will not be admitted.
Okay.
If you can show me the linkage that someone testified to that photograph, that's fine. Next would be C6, document of a forensic medical report. The defense is not offering it, the prosecution wants it in. Yes.
I thought this was objected to by the people, and we basically didn't proceed it. It's the cover sheet for the sexual assault kit for Mr. Spector, and the court disallowed it before.
Okay.
Actually, it was Bob Middleburg. I asked him about this document on cross-examination. It had been previously marked. I don't know if it had been shown to anybody or not. Kerry Caruso actually wrote it. But Bob Middleburg, I asked him if there was a suggestion that Mr. Spector urinated before he gave his sample. Would that count as voiding? Is that basically voiding the bladder? He said, it depends, and gave me a long-winded answer. But this is the document that I used, and this document does, in fact, show that he urinated.
Was there, Mr. Plourde, you're indicating there was a sustained objection?
When we tried to get into it with other witnesses, it was...
That may be, but the question is, at some point, was it admitted?
No, the Middleburg just said this was provided to him as an expert, and he did. I do remember that testimony that Mr. Jackson just mentioned, but I'm trying to look at the
So somebody formed an opinion based on this, in other words?
No, he said he didn't agree with Mr. Jackson's proffer, so...
Dr. Pena didn't agree with half the stuff Mr. Plourde showed him, but all that stuff's coming in too.
Where does it say about voiding or going... basically, this is a sexual assault standard OCJP form. It's a government form saying, okay, did you go to the bathroom? Did you wash your hands? It's all information from Mr. Spector that was objected to. Okay.
I understand that, but what did I rule when you made the objection?
That when we tried to get it in, you ruled it couldn't come in. It was hearsay, etc. But when Mr. Middleburg was, I don't know if it was published to the jury at the time, but Mr. Jackson did ask questions about it. Were you given this?
Mr. Jackson, you need to find the area where you asked questions concerning this, and I would like to know what the rulings were when he was, I want to take a look at it and see what the basis of it was and why it was used, and then I'll make a determination. So for the time being, C6 is not admitted subject to the people linking it up.
Okay, very good.
L6 and M6 are not being admitted by agreement.
That takes us to Q6.
Okay. Q6, parties are not admitting by agreement. V6 is being objected to from the principles of bloodstain analysis.
Just, can we have 1 second?
Sure.
You say G?
No, V6.
I think there was
testimony from regarding that, what it means that this is what Stuart James and other people, and also Mr. Peck.
I remember Mr. James testifying about the pattern and also the hole from the bullet.
And then I think Dr. Harold also was shown this, and there was issues with this back spatter, forward spatter, and it was explained. That's right.
It absolutely was, and every expert said that is not indicative of the pattern in this case. That's completely misleading. That's shooting into a sponge, which Mr. James indicated. I think James and Kish did this experiment, and that is not indicative of the backspatter pattern that you have in this case.
But it was shown to witnesses. The witnesses did testify to it. The fact that ultimately the weight may be useless because of just the reason you stated, it still is admissible. It goes to the weight the jury will give it when you point out in your arguments, folks, we're not talking about sponges. But people said, yes, this is what it shows, this is what it does. And then to say it's a sponge, so it's not a live experiment or whatever, so therefore it's not admissible, I don't believe that's a basis for objecting. Witnesses did testify to this as to how they used it or didn't use it or why it's relevant or not relevant.
I guess my point would be if they testified that, yes, I used this in coming to a conclusion or opinion, yes, I used that document because it's indicative of what we have here, yes, I used that because that helps us get to a final conclusion in this case, that's one thing. But I could show the witness this and say, do you see this in my hand? Yes, I do. Does this mean anything to you? And does it have anything to do with this case? No. That doesn't make that admissible. They were shown this in an effort, I think, by the defense, because I can guarantee you, if this comes in, everybody hide and watch. Somebody's going to stand up and say, This is what you'd expect to see on Phil Spector's jacket.
And-
And this is not what the
And there would be an
evidence
enormous objection which would be sustained.
suggests. It would be an enormous objection.
That was clear from the testimony that this was done a certain way. It's not meant to replicate what would happen or not happen, because, and frankly, nobody really knows. This is a sponge. It demonstrates what backspatter is under certain conditions.
And that's the reason why it's admissible, and again, its weight is minimal, but it is relevant. The objection is overruled.
Okay. Thank you, Judge.
Okay? So now we're down to A7, a hand-firing exemplar gun, which is being objected to.
I have the same objection, and I think that's probably going to be the same
Right, and
ruling.
the same ruling as A7, it's admissible. B7 is CD.
That was Dr. Spitfire's weapon, which we've seen a number of times. There's
Oh,
testimony about it.
that's admissible. Why is it not, Mr. Jackson?
What, this?
B7, the CD. He's explained, he testified to it and what it meant, what he was doing.
Oh, okay. This is Spitz actually firing the gun.
Yeah.
My objection was...
Non-representative again.
Correct.
Different gun, different ammo.
I know, and that's all been testified to, but it doesn't make it inadmissible. It goes to its weight.
Okay.
Okay.
That's fine.
Thanks. All right. Next,
G7.
G7, is not being moved, but the people want, it's Ms. Clarkson in the chair with taser, leads, and discs. Well, there's been lots of testimony concerning that.
There has.
We'll submit.
All right, then, G7 will be admitted over the defense objection, but on the motion of the prosecution. Okay, H7, I7, and J7 are being objected to. H7 is a videotape.
This, I wanted to make sure I'm clear about what this is. Is this the animation of the stuff coming out? And I think the witness indicated it's not supposed to be representative. It's just it's an animation. I'll withdraw my objection on that.
Okay. H7 is admitted. I7 is a CD of a CEG gun tutorial. GEG gun tutorial, pardon me.
I believe this is the same thing. It's the second of the two
Be
animations.
safe.
I'll withdraw my objection on
Okay.
that as well.
I7 is admitted. And J7 is CD Suede at,
It's actually supposed to be
It
suicide.
said suicide at PD. This is a
that's
CD that was
exciting.
never shown.
you're right. it is not
Yeah, definitely
admitted.
be
The
safe
court
on your
is already-
travels.
I'll note your request to put it in. The court kept it out. It was too prejudicial under 352 and did not establish anything that was not testified to by various witnesses which had to do with movement after a traumatic head wound.
And Judge, before we move on, if the court has a pen and paper,
Oh, yes, we do get those.
at page 70, I'm sorry, at page 7701, lines 3 through 18 is my cross-examination of Robert Middleburg. Upon being shown a copy of the Kerry Caruso report, the urination report,
Right.
He does remember that it's one of the documents he reviewed. He talked about the highlighted portion called recent hygiene information, the box labeled urinated. The box isn't under a portion marked sample, it's under a portion marked recent hygiene information, et cetera, et cetera. So I believe he did testify.
Well, did he ultimately, however, he did testify, okay, but the bottom line is, based upon that testimony, did he do anything as opposed to, yes, I looked at the document, but did he rely on it? Did he use it? Did he interpret it? Did he factor it in? That's what I'm looking for.
I guess I would have to go to the actual transcript to see, because all I have here from my summary is he remembers it is one of the documents he reviewed. And if
Okay.
he reviewed that,
But
Before he
on
testified.
other grounds, because to a certain extent, I believe it was objected to on hearsay grounds, I'm not sure. I can't remember what your initial objections were when I kept it out on the defense case.
this may get us, I don't know if this gets us any
Okay.
closer or not. Witness says he isn't sure of whether that is consistent with Mr. Spector actually voiding before giving the sample, or if it refers to giving the sample itself. The box isn't under a portion marked sample. The witness cannot interpret the urinated box as it is checked here. The box recently urinated is marked yes. Recently defecated is marked no. Voiding just means going number one. I remember that part.
What Mr. Jackson was doing, he was trying to cross-examine Mr. Middleburg on the urine result, which didn't come in their case, saying that the urine result was X and that this was somehow a proper void for a urine collection, which Mr. Middleburg never said it was.
Yeah, I would not want to be in Phoenix, though, just because of the heat. I bet it's going to be hot,
Did
bro.
anybody testify to how that document was checked, how it was prepared?
Bring your sunscreen.
No, we didn't call Carrie
Okay.
Caruso to
The
stand.
Light
objection is
colors.
sustained, it's not coming in. I mean, you're not going to get it in, so that's, there we go.
I'm sorry, which
That is,
That's
that,
C6, I believe.
C6 is not admitted. Okay, we're down to, let's see,
I think we're
L7.
also,
Photo of Lana and friends at dinner.
right.
I can't remember, who's, was that ever,
Yes, it was testified to, it was described, she was identified by several people in this photo. I think Jennifer Hayes, Pumpkin Pie, L7.
what would the objection be?
Oh, this is a photograph of Lana with a bunch of people with her legs stuck up on the table. What does that have to do with anything, and how? Why
I
is
think,
that?
is this one that I let you mark, but I said I'll get to it when the time comes?
No, you vetted them, and I gave you a series, you vetted them, and you said this one was okay. You kept a bunch out, but this one you allowed.
This was shown to the jury.
Yeah, this was shown to Daniel Stark. I mean, Daniel Stark was shown this photograph.
Okay.
With her leg on the table. It's pretty clear what this is being used for. And my objection is the same now as it was then. Why are they choosing this photograph over any other photograph to show to a firefighter who fixed her wrists, or says he fixed her wrists?
But did he identify it?
Yes, he absolutely.
You know,
Under 352, we are objecting to
Okay.
this photograph.
all right.
It's been identified, it's been testified to. I think
Yeah,
Jennifer
but
Hayes,
when you-
they mentioned, I think Pumpkin Pie even identified where that photo was taken.
Well, I'll tell you what, if Pumpkin Pie identified where that photo was taken, I will consider admitting it. If it's just used, it's clear who Daniel Stark treated. This photograph really has no connection for the purpose of identification, except that it is, and it's, by the way, before you get too excited, it's not overly salacious, it is slightly salacious. There are pictures, as I have quoted or I have stated, you have your good photos, they have their bad photos. I think it's, some are needed for basic identification. Trust me, the jury's going to understand. I just say this, you do what you want with them, the jury's going to understand this. Don't underestimate your jurors.
No, and Pumpkin Pie is right in the middle of their seated.
Find whether or not Pumpkin Pie,
There she is.
yes, I understand. Believe me, it's not quite as salacious as the people would have me think it is, but I want to see whether or not Pumpkin Pie identified that particular photograph.
Looks like Mr. Broom in the back there.
Don't
I
answer.
think that it was taken in San Francisco, is what Pye's testimony was.
Yeah, she's basically, to describe the photograph, there's a group of people obviously having a good time, there's wine on the table, and Miss Clarkson has her leg up, and she's basically showing a lot of leg. Okay, it's no big deal to be blonde.
Yeah, it is no.
You know what? I'm going to reconsider. It's going to come in. This is just
Oh, my
not, it's
God.
not as bad as you think it is, Mr. Jackson. It's just, there's no reason. It was identified. It can come in.
Okay.
And you know what? And you're free to
5
argue whatever
minutes
you
or
want at the
Sure.
time comes,
And
and
you
both
may
sides are free to argue whatever they want at the time comes.
Judge, I'll withdraw my objection to the next one. I don't think.
Okay, M7, the Brentwood Blondes
I
program?
think that was a mistake.
All right, then M7 is in.
And that takes us to D8.
Right.
Kaplan drawing. Oh, she described the fingernail.
Right, and the problem I've got with this is the drawing that she, sorry, the object that she drew on the thing. First of all, she qualified it by saying, well, Ms. Bodman, I can't draw, and I can't draw it to scale. So she sketched this out and said, that's the best I can do. It's not to scale. It doesn't help anything. I mean, she described it orally or verbally, and she specifically indicated that this is not indicative. So I think it's...
Well, it's for an artist rendition, and that clearly goes to me to the weight, not the admissibility. She was asked if she could draw it. She drew it to the best of her ability, and you're free to point that out. The objection is overruled. D8 will be admitted.
And I think we go to...
F8, carpet, and I guess BS is bloodstain, I hope so.
It is.
yes.
It is. Carpet,
Because there's
yes.
never been anything else that would fit that description in this
Pumping.
photo.
Absolutely not.
It's all pumping,
Judge,
pie.
if you want to take a look at...
It's up on the board.
Oh, good, okay, 8 and 9 both. I'm sorry, D8 and E8 both.
Wait, I thought we were on
Correct me up, Dave.
F8.
We're on F8, and then there's G8 plaster on the carpet. Are those the ones you want me to look at?
Yes, Judge, sorry about that.
Okay, got it.
There's no foundation for either of those photos. I think Ms. Kaplan was shown both of them, and she specifically and roundly indicated she couldn't lay the foundation for them, and she didn't know. She said that she had never gone outside of the foyer area, which the carpet with the little white things, the plaster on it, was in a different area of the house, and she didn't see that.
Okay.
Please, that's the plaster, that's correct. This is the previous one, I believe, but Detective Tomlin testified that that was the blood stain that was where the chair was, et cetera. So I think as to the former one, that was eventually sent, I think there was some testimony that was the one that was sent to the crime lab by Dr. Lee eventually.
If Detective Tomlin testified to that, I've got no problem. I don't remember him ever being shown this photograph.
Okay, you have, at this point, as to F8 and G8, the objections are sustained. However, as to F8, if you can show me testimony that Detective Tomlin as to that picture identified it, then I will reverse my ruling. Next would be I8, drawing of a jacket.
If I can have just a second, I'm looking at I and J.
Thanks
Our
everyone for
objections to
hanging
these are
out
both
this
on hearsay
morning.
grounds. These are, again, not
Another
part
video
of the
down.
normal business records. These are Steve Renteria's personal notes that were not done under penalty
Get
of
closer
perjury.
to
He indicated
finally
that,
starting
he was
closing
not
arguments.
as specific about the size and location of
Been a long
things
time.
as Lynn Harold was. And we've got the jacket, the actual jacket with the actual photographs, including photomicrographs. I think this is under a hearsay objection. This is
I believe Mr. Renderia identified them, did he not?
Both of them, he went through each.
Yeah, that goes to the weight again.
okay. I'm not saying he didn't identify him. He did. I'm just saying it's
That goes to the weight. The objections as to I8 and J8
And J8.
are overruled. They're admitted.
Judge, are we going to take a look at break?
Yeah, we need to. I don't even know if we're going to finish with the exhibits today. We'll try. All right, well, okay, we'll do the best we can, and then I think we'll end up working through Thursday on the instructions. So be it.
Judge, just before we break, could I just throw out a little brain teaser that we'll all need to think about for a minute? I was speaking with Mr. Jackson earlier this morning, and he told me that they intend at some point in their argument to show video clips.
Quite a few, Dave. We're getting there, though.
Broadcast from the courtroom. And we're going to object to that because it's not evidence, it's not part of the record, it'll never be part of the record. I mean, there's several other levels of objection. For example, you're going to have to tell the jury they can't consider that as evidence.
There might be a few in here